Number 66, welcome all. Counsel, you want any rebuttal time?
Yes, I'd like to reserve 5 minutes, please.
5 minutes. You've got it. Go ahead.
Good afternoon, Your Honors. My name is Corey Stoughton from the New York Civil Liberties Union. I'd like to just briefly introduce Chris Dunn, also from the NYCLU, and Gary Stein and Danny Greenberg from Schulte, Roth, and Zabel, our co-counsel representing the plaintiffs in this matter. This case is a constitutional challenge on behalf of thousands of poor people who are charged with crimes in 5 New York counties, who stand in court every day without any lawyer or without a lawyer who is capable of representing them. As a result, they spend weeks or months in jail before trial, are forced to accept inappropriate guilty pleas, face excessively harsh sentences.
One of the things you mentioned, I apologize for interrupting you, but one of the things that you mentioned was that there is no counsel at arraignment. And I'm from upstate New York, and I know that arraignments can happen at 2 o'clock in the morning and sometimes in the home of the town judge. Is it things like that we're going to be confronting in this case, should you prevail?
It depends on what happens at arraignment. The complaint alleges that it's typical in arraignment. For example, in Washington County, it's typical for defendants in cases in arraignments like that to accept guilty pleas without the presence of any lawyer. It's typical in all of the counties, the complaint alleges, for bail adjudications to be made without any lawyer or any advice of counsel.
Well, you would solve the problem by simply always locking the guy up?
No, to the contrary, Your Honor. If the arraignment is a critical stage, as defined by this court.
Okay, but you're in Judge Piggott's home at 2 in the morning, and there doesn't happen to be a defense lawyer available. What are people supposed to do?
Well, they should have a lawyer, or they should be released. That's what New York law contemplates.
Are you saying by design in those counties there is not a lawyer, period, and that's the accepted way of going about business?
That's exactly what the complaint alleges. The complaint alleges that very often that arraignments are in practice, in effect, a critical stage because adjudications of critical rights are made without the presence of attorneys.
So you're arguing that systemically that needs to be corrected by what? By the infusion of state money, by a different system? By what? How would you
remedy it? How would you remedy that?
Well, to get to remedy, we first have to understand what this case is about. And this case, the legal claim...
We're at the motion to dismiss stage, right?
That's right. We're at the motion to dismiss stage. And so what we are here asking the court to do is to recognize that a legal claim has been stated in this case.
Well, I'm sorry, go ahead.
I understand, but I'm trying to get a handle on what it is practically that you're looking for. Because are you saying we need to have attorneys 24 hours a day on call? I mean, arraignments have to be done within a certain period of time. And there's no question in our upstate justice system it occurs all hours of the night and morning.
That's right, Your Honor. What we are arguing...
What are you proposed? What is it you're seeking?
What we are seeking is an order from this court that the state has to remedy, establish, and eventually prove violations.
What's the specific remedies? What are the solutions to these problems that you're proposing?
Well, with due respect, that is the prerogative of the political branches.
You're saying to us, let us bring the claim and worry about the remedy later.
Well, that's the first argument, but I'm willing to go farther than that. I mean, to be sure, as the Court, I think, clearly understands, this is a motion to dismiss. And just as in the first Campaign for Fiscal Equity case, this Court has clearly held...
But you're saying you're not arguing for any particular system,
that's
right?
Correct.
You're arguing that if the complaint is true, that people's rights are being violated. Is that what you're saying?
That is precisely correct.
And to let you go on with this case, make your case, and then see where we go from there.
That's precisely correct, Chief.
In CFE, we found a constitutional violation. Do we need to find constitutional violations here before we can move any further?
You only need to find that the complaint states a claim for a constitutional violation.
Aren't there disadvantages to going down the road saying, well, we'll worry about the remedy at the end? And then isn't there a danger that you're going to get to the end and say, oh, gee, I wish I worried about the remedy sooner. There's no remedy I can grant here. There's no remedy that's going to do anybody any good. The only remedy is more funding.
No, but there clearly are remedies that can be ordered. And
so give us a few.
Well, for example, the complaint alleges that the complaint alleges ongoing violations of people's constitutional rights, and that those ongoing violations are caused by systemic failures in the system. Can you
give me something more specific that something specific that you want the court to do? Assume that we have read and believe and are convinced by everything you say.
Well, for example, the complaint alleges that one of the systemic failures is the absence of counsel at critical stages. So the court should order the state to remedy the constitutional violation of the absence of lawyers at critical stages.
By having lawyers on 24-hour call at all times.
How the state chooses to do that?
I'm sorry, go ahead.
But don't, I mean, isn't there a limit to the glibness with which you can say how you do it is your problem? At some point, whether it's practicable, whether it makes sense, has to become the court's problem. And doesn't it make some sense to worry about that at the beginning?
Whether it's practical or makes sense is only the court's problem to the extent that the state's chosen solution continues to violate the Constitution.
You're asking for both injunctive and declaratory relief. Can you define for us specifically what injunctive relief you want and what declaratory relief you want, even though I understand that it would be down the road? What we have to do is sustain a cause of action for you so that you can continue. But specifically, what is it that you're seeking down the road at the end? Should we say that there's enough here to move you along?
The declaratory relief that we are seeking is a declaration that the systemic deficiencies that are alleged in the complaint that we will prove, given a chance, are actually causing ongoing violations of the constitutional right to counsel, and that the state must take steps to remedy those specific and proven systemic deficiencies.
And since Gideon, there's been a system in place, right? States around the country have put systems in place to address this issue of the right to counsel, right?
That's correct, Your Honor. And New York has a system.
And New York has a system, as do the other states, as they are required to do by Constitution, right?
That's right, although the Constitution requires more than just setting up a system and hoping that it meets the
Right,
constitutional
but
standards.
as I understand it, let me understand what you're saying here. As I understand it, you're arguing that that system that's been in place, at the very least since Gideon, is broken, systemically has flaws in it, and that going forward, the system has to be repaired, has to be fixed. That's your argument, and injunctive and declaratory relief that would go towards fixing that system, whatever the system is, whatever the particular systemic cure is, that's what has to be done.
That's exactly right. And to answer your question, Judge Smith, that although I understand you're seeking specificity, and Judge Saparik, in what the remedy might be, as the CFE cases teach, this Court's job is to identify and enforce constitutional violations and enforce constitutional rights.
But often courts do it on a case-by-case basis. That is, if there's a particular person not getting a fair trial, he gets his conviction reversed, or he gets counsel assigned, or he gets some other remedy. Is there precedent? Is there really precedent for a lawsuit that says the whole system is failing, fix it?
Yes, there is precedent. There is, well, to begin with, to back up, the State's position that the constitutional right to counsel is enforceable only in the context of the criminal proceeding is just plainly flawed.
Okay, but I'm sorry I distracted you with that, but what about the precedents you were going to cite for the systemic failure?
Well, Your Honor, there are 11 cases cited in our briefs from various State courts, 2 from the highest courts of other States.
Any from New York? Got any in New York?
And, of course, there's the New York County Lawyers Association from the First Department, which also recognized a cause of action for relief from systemic violations, for prospective relief from systemic violations.
I don't want to fence, but I see your point. It's a fair answer. But is it also fair to say that our court, as far as you know, has never actually upheld a systemic failure case?
A systemic failure case in the context of indigent criminal defense, that's correct. Although
In the context of
indigent criminal defense services.
Any context.
But the campaign for finance,
CFE, but even CFE, as I understand it, although I see what you mean about that case, but CFE came down to saying there's a bottom line number of dollars. We don't know what it is, but there is a number that someone's supposed to figure out that's required by the Constitution. Are you asking for that kind? Is this that kind of case?
No. In fact, this case is much easier in terms of the justiciability and the determinability of remedy. That's for 2 reasons. The first is this is not a funding case. This is a case about constitutional rights.
How much does it matter that this is a case about the justice system? And what you're arguing is there's an imbalance in the justice system, I assume is the thrust of what you're really saying. How much does it matter? How does that affect our role, that this comes out of the justice system?
Well, that was going to be my second point, and it matters a lot, and it matters for two reasons.
Tell us why.
One is that this Court has held that when constitutional questions arise that deal with the justice system, this Court's role in enforcing that and policing the judicial system to ensure that constitutional standards are met is critical. But the second reason is that unlike in the CFE cases or in other systemic reform cases, the standards to be applied in this case are clear and judicially enforceable and judicially created because they are interpretations of what the constitutional right to counsel mean. Those standards come from decades of case law from this Court and the Supreme Court defining what the right to counsel is, defining the right to counsel as the right to meaningful and effective assistance of counsel at all critical
The result
stages.
is reasonably well defined, but you're asking us, aren't you, to say that the means employed to get the result aren't working, that they should use other means. That is, the system is yeah, you're not, you're not saying, well, maybe you are, but you're not certainly not saying only have lawyers on 24-hour call at arraignments or be sure that everyone has a lawyer at an arraignment. You're saying you must do something to deliver, to more efficiently deliver the product.
No, we're not saying that there needs to be a different kind of system for delivering public defense services necessarily. What we're saying is that the way public defense services are provided now violate constitutional rights in specific and identifiable ways, and that those systemic failures that are causing violations of constitutional rights need to be cured.
You're not, you said that's a systemic failure, but you're not asking us to change the system?
Well, the system must be repaired, but that there could be a more efficient way of delivering services is irrelevant.
Are you arguing really that there's no system in place?
No. What we're arguing is that there are identifiable failures in the system that are causing constitutional violations.
Tell us, for example, how you would improve the 18B system in these counties. How would you go about improving that?
Well, Your Honor, our task before the Court here today is not to describe how to build a better public defense system. It's to show the Court that the system is violating the rights of individual people.
At all steps of the process?
At all steps of the process.
The problem with that, if I understand it, is there's 62 counties, and I think each one of them seems to have their own manner in which to do this. You've pointed out, you have Schuyler, Washington, Onondaga, a few counties in Ontario. If you prove, as you intend to, that the system does not work in, let's say, Onondaga County, what does that do to the other 61?
Not much, Your Honor.
Therefore,
why
why would you then want to have a class action lawsuit wherein you're attempting to change the entire system?
We're not, Your Honor. To be very clear, this case is about 5 counties. And the complaint alleges that in those 5 counties, the rights of indigent criminal defendants are being violated, that there are no lawyers at critical stages, that there are lawyers who are not conducting any investigations, they are not speaking to their clients, they are not negotiating.
It's undoubtedly true in every county that there are some bad lawyers who are assigned. At what point do you have enough to have a cause of action?
Well, whatever that point is, the complaint alleges it. The complaint is not a collection of 5 or 10 or even just the 20 stories of the plaintiffs.
What's the equalizer here? Is the import of what you're saying that the state is the equalizer to make this better or not necessarily?
I'm not sure I understand the question.
That if the counties are not producing a system that defends people's rights and liberties, who fixes it?
It's fundamentally and quintessentially and I think indisputably the state's responsibility.
So the state is the equalizer. The state is the vehicle to make it better rather than the counties.
Because it is their responsibility. Now, how the state goes about making it better and the
right.
political consequences of that are
but the state is what we're focused on here.
That's right. And just to go back to Judge Smith's question, I want to emphasize that the complaint's allegations and the allegations of the Kaye Commission report, which are incorporated into the complaint, which of course must be taken as true on this motion to dismiss, clearly state a claim for massive systemic violations of the right to counsel.
Well, how would you define the words massive and systemic? Are there violations in 5% of the cases, 10%, 2%?
No, we define it as the fact that it is routine for lawyers not to be present at critical stages. Your Honor, yeah, routine. I mean, that's what the allegations of complaint are.
And would your case fail if you did not prove it was routine?
Our case would fail if we could not establish that there are actual ongoing violations.
Oh, but of course there always will be, because no system is ever perfect. Is there a minimum number you have to? There is a minimum number, surely you would have to establish for your case not to fail.
Well, the legal standard applicable in a case like this, as established by the consensus of cases that have looked at this the problem of the right to counsel from a systemic and prospective relief perspective, is that the plaintiff should establish that there are ongoing violations, as the complaint alleges that there are in these 5 counties, and that those violations are caused by systemic failures, which every day, in every case.
So you're not talking about missteps. You're not saying that in a particular case there's a misstep. Obviously something happens that's wrong in the particular case. You're saying that's a way of life.
That's right. Those systemic failures which we will, by proof eventually, hopefully, given the opportunity, establish are the cause of those ongoing violations exist all the time, every day.
How do we know from what you're going to present, or how are you able to prove that it's not a misstep, but rather, again, it's a systemic, it's a way of life, it's the way things by design are done? How are you able to show that when you're talking about 5 particular cases? How do we know that it's systemic in the true sense of that word?
Well, the allegations of the complaint get us there. The allegations of the complaint...
How does your complaint show it's a consistent statewide problem? You've only got 5 counties involved here out of 62.
Your Honor, it doesn't. This case is only about 5 counties, and the relief sought in this case will only be
Well, then
as to those
why
5
do you
counties.
say... Why do you
So
say...
you're going to seek
sorry.
additional funding just for 5 counties?
Your Honor, the complaint does not, the case, I should say, does not seek additional funding.
Why do you say in paragraph 15 that New York's fragmented system of county-operated and largely county-financed indigent defense services fails to satisfy the state's constitutional statutory obligations to protect the rights of the indigent accused?
Well, that particular complaint might not have been as specifically drafted, but the complaint as a whole only seeks to establish a claim, and it will only seek relief as to the 5 counties that are
So this
identified.
is similar to CFE, where it was the relief that was sought was only for the New York City schools, as opposed to schools in other school districts.
In that sense, yes, it is like that.
Can you envisage any...
Why are these problems specific only to this handful of counties?
I'm not sure they are, but that's all that the complaint endeavors to prove, or to allege, I should say.
How would a decision here affect other counties? There could be other counties who may want to bring similar type claims.
But there could be, but that's not this case. This case is about what happens to the thousands of indigent criminal defendants that are in...
It will have
in
precedential
these 5
value.
counties.
Whatever we do here will have precedential value.
It certainly will, but in terms of establishing what the proof is, in terms of the proof that the plaintiffs will put forward, given the opportunity to go to trial, it will be confined to the experiences of the thousands of indigent criminal defendants, like the named plaintiffs.
But the basic import, I assume, is that these counties are representative of what's going on in this state. Is that the import, or is it really limited to these 5 counties?
It really is limited to these 5 counties.
And why are they joined? I mean, are the funding identical in all 5 of these counties?
The funding, well, in terms of the state's contribution to the funding, the complaint does allege it's about the same. It hovers around 50%.
Well, I mean, some of them will have a public defender, a county public defender. Some of them won't. Some will have assigned counsel. Are all of these identical in the way that they've determined that they're going to fund their indigent prisoner program under 18B?
The complaint, although there are, of course, different systems in all 5 of these counties, well, in fact, the 5 counties represent all 3 of the different kinds of systems that New York counties can select from.
That was by design? You picked them because they represent all the different systems?
Because the point is that it's not about the particular system that the county chooses. The complaint's fundamental allegation is that those violations of the right to counsel are caused by systemic failures that are an inevitable result of the state's abdication of its responsibilities.
You say the case has nothing to do with funding? Well, I thought I saw some mention of funding in the pleading.
Well, the complaint alleges that the systemic failures, one of the systemic failures that is common to these 5 counties is a lack of resources.
So you are extrapolating from the 5 to the 62. What you've done is you've taken the 3 possibilities under 18B. You're suing, saying each one of these possibilities is inadequate. Therefore, the other 57 counties' systems are inadequate as well.
No, because it's not the inadequacies of, say, an 18B system or a public defender system or a legal aid society that are the cause of the violations of the right to counsel. The cause the complaint alleges is the lack of training for lawyers, the lack of supervision for lawyers, the lack of resources for lawyers. These are public defenders and 18B lawyers who have no computers,
all those things do
no
cost
training.
money.
They may, but
shouldn't we know before we decide whether to uphold this complaint, whether there's any end to it, any possible end to it, other than an award, an order saying the state has to put a lot more money into this system?
The order in this case will be that the state has to remedy the proven constitutional violation.
Is there any-
As this court held in
But
CP,
is there, realistically, is there a way to comply with that without spending a lot of money?
there may be or there may not be, but this court has held again
Is
and again in
that a good
Foster v. CP
idea
that that's
to order
irrelevant.
the state, say, here's a problem, a systemic problem, order the state to fix it, and it may or may not cost money, and we'll worry about that later?
Your Honor, just that this court every day issues orders that require the state to comply with constitutional or statutory obligations that may in the end require expenditure of more money.
The bottom line is, if it requires money, yes, that's what'll have to be done, is the answer, right? But you're not saying that that's the only way to solve it, but if it is, so be it, I guess, is what you're looking for. Is that right?
That's right, although I want to make one thing clear before I sit down because I see my time has expired, that the order to spend money would be no part of the relief plaintiffs would seek. That is only the case to the extent that the relief that the court would order ultimately in this case, should we prevail, might in fact require that. But
Can you imagine any kind of relief that wouldn't? Can you imagine any kind of remedy that wouldn't entail more resources, more money being spent?
Well, no one has ever done an analysis to give us any information about how much it would actually cost to effectively deliver public defense services in these 5 counties.
Well, I guess you're saying however much it is, it's more than what's presently being done, if your allegations are correct.
Well, I'm not sure that is true. It may be that if we stop locking people up unnecessarily by setting bail too high and having no lawyers to advocate them, that we might save money at the end of the day.
But in order to reach these 5 counties, doesn't it imply that this would have to be a statewide fix?
I'm not sure that's necessarily the case, Judge Jones. I think that it's ultimately up to the state, the approach that it takes to solve these problems.
Okay, Counselor, you'll have rebuttal time. Counselor?
Please, the Court, Barbara Underwood for the State. Plaintiffs are asking this Court to recognize a brand-new constitutional right. No appellate court has ever found a prospective, systemic violation of the constitutional right to counsel based entirely on counsel's performance, and for good reason. While courts can sometimes address the absence of counsel this way, because absence can be
There are some allegations of absence, aren't there?
Not really. Plaintiffs try to make this a case about absence rather than deficient performance by pointing to the arraignment context that was discussed a little bit just before. But
that's pretty clear under federal law, so that's a pretty serious allegation here.
no, it's actually not clear. As a legal matter, appointing a lawyer soon after arraignment satisfies the Constitution, so long as the defendant doesn't irrevocably lose critical rights at arraignment, such as by pleading guilty. Rothgary, which plaintiffs rely on for their federal claim, did not uphold a claim for counsel at arraignment. It reversed the Fifth Circuit, which said there couldn't be a violation at that stage because the DA wasn't yet involved, said that reasoning was wrong, and remanded to determine whether counsel was actually
Aren't they saying that at every stage there is a constitutional violation? Isn't that really what they're saying? Whether it be a lack of counsel or a lack of meaningful counsel, isn't that what they're saying? At each and every stage there's a constitutional violation. And why couldn't you allege that and prove it?
Well, they're saying 2 different things, and the reason I make the point about arraignment is that I think that a systemic practice of denying counsel where guilty pleas were being taken would allege a constitutional violation that could be addressed in advance. But that's not what they have here.
But not the setting of bail, for example.
Correct. Not the initial setting of bail. As long as counsel is appointed soon enough thereafter to come
Counsel
in.
can go back in and make an application
Correct.
to reduce the bail.
But let's talk about this. There's allegations in here, for example, somebody's in jail, they can't reach their lawyer. I never heard of a mailbox being full, but apparently it occurs. Lawyers that won't collect calls from the prison. Obvious problems with the way these cases are being handled. If there was a cause of action that said that the state, if they're going to contract out this constitutional duty to the counties, should at least make sure that the counties have in place a system whereby they assure that that mandate is being carried out, that there are standards, that there are rules, et cetera. Wouldn't that make some sense? Hard to say no to that, isn't it?
It might make some sense. I don't think the Constitution requires it, which is the point here. And the reason I'm distinguishing absence of counsel from deficient performance is that once you get into deficient performance, as for instance, the Massachusetts court, whose case they've cited, recognized, you have to judge whether the decision of counsel not to make a bail reduction motion or not to investigate a defense or not whatever.
Don't you think that the performance can be so woefully inadequate that they could make a showing that it equals the lack of representation?
I think
or worse, the counterproductive representation? Why couldn't you make out a case along those lines? In that 102-page document, if they were able to, and if those allegations are true, does that show constitutional infirmity?
No. I'd like to point out that none of their 20 plaintiffs alleges that they took a plea that was uncounseled. And, in fact, if there were such
They do allege they spent a long time in jail.
They allege they spent a long time in jail, but not that they didn't have a lawyer for a long time. Every one of those allegations that alleges that they didn't have counsel at arraignment. And
if they're in jail because of a lack of representation or a lack of meaningful representation, isn't that a constitutional violation? As we know about the right to counsel, could there be any doubt?
It might be so.
So what could be more important than taking away someone's liberty?
Case by case, it could be determined. There is nothing here that says that they didn't have a counsel in time to deal with their incarceration. The only person who didn't have counsel for a long time was the person who alleges a dispute about eligibility, and he was out the whole time that he was having this dispute about whether he was eligible for appointed counsel or not. So there is nobody here who alleges, none of the 20 plaintiffs alleges that they lost critical rights without counsel. And their general allegations, if I could just point to the general allegations, are all quite artfully unspecific. They say that
if I could, suppose they may disagree with you about the right to counsel at arraignment or indeed about the right to counsel at various other points. If they brought a narrower lawsuit, testing only that, saying the state says it doesn't have to provide counsel at arraignment, we say it does, that's a justiciable lawsuit, isn't it?
Well, except for the fact it might be. If you narrowed this complaint to the allegation of no counsel at arraignment and you held that there was a right to counsel at arraignment, even if a plea is not taken, because none of these 20 people pled guilty at arraignment, then that would probably be.
But your objection to that would be on the merits, but not on justiciability.
That's correct. And
could that be a cause of action that could go forward in this case? I mean, it's not pled as a separate cause of action.
Well, I don't think it's pled that way.
Right.
If you were to narrow this complaint, if you were to hold that the court below correctly dismissed the complaint except for that allegation, I think that that's justiciable. I just think it's an incorrect understanding of where the right to counsel applies.
That substantive issue would be presumably a later motion to dismiss or summary judgment.
None of these plaintiffs, but because I think, and I think the law is, that the right to counsel is not violated if no right at arraignment, if no right is lost, and none of these 20 defendants lost a right.
Well, what is the picture that they lay out in this 102-page complaint? What does it show to you? They're all things that have nothing to do or don't show, even if proven, do not show a constitutional violation?
They are all performance questions which, to adjudicate, one would need to know, as we started to do at the preliminary injunction hearing that was then terminated. You'd have to know whether what the lawyer didn't do.
Yeah, but this is a motion. But this is the motion to dismiss.
I understand that.
And isn't that critical?
No.
In terms of the point that you're making, that it's a motion to dismiss. What are we to do now in this procedural posture? We're just to say, well, they can't really show that there's a performance issue here. Let's not even let them try. Does that make sense?
It makes sense to reserve performance for adjudication on an individual basis. Because that's the way it's clear.
Why can't you do it this way?
Because you can't tell this way without adjudicating.
But what if we let it go beyond the motion to dismiss stage and we denied the motion to dismiss? Why, maybe you'd be able to tell.
The reason the right to counsel has never been treated that way, and I dispute that there are 11 cases are.
Yeah, but answer my question. Why couldn't you give them the opportunity to show it, with just on the issues that you're saying. You're saying you can't do it, you can't do it. Maybe they can do it.
Because at the end of the day, even if they proved that of their 20 plaintiffs, some number of them, 1, 2, 10, 20, had on an individualized basis a lawyer who didn't do something that should have been done, first of all, in these cases, there would be no prejudice, most likely.
Well, suppose that is there some number, suppose they prove that all 20 and maybe about 38.6% of all the others are getting deficient performance. Is that a valid claim?
I think the way it would have to be stated for it to be a valid claim would be for there to be a policy of some unconstitutional practice.
So you would say that inefficiency in delivering the service, no matter how gross, cannot be isn't the basis for a claim against the state.
For a systemic and anticipatory claim in which it has not in which you're attempting to adjudicate in advance of results, or in this case, you've got results without impact because you've got mostly.
So even if there were, and maybe they're not even quite saying this, if there were a complete breakdown of the system, not in 5 counties but in all 62, that the remedy for that would be on a case-by-case basis?
You know, yes, except I will say that criminal procedure reform has generally proceeded that way with systemic effect, because, of course, if an individual defendant shows that he actually was denied the right to counsel by some practice that is widespread, that holding by this
So
court.
we have to wait until there's a conviction, till the injustice takes place, rather than to preempt, to stop in the future that from taking place. You can't do it that way. You can't say that we're looking at this and they're trying to prove the allegations in the complaint in order to avoid injustice, wrongful convictions, whatever the ultimate result is from a system that they're alleging doesn't work.
Judge Lippman, if this, what they allege has been going on for a long time, it ought to be
They say it's a way of life. That's what they say.
It ought to be possible then to find a defendant who actually suffered ineffective assistance of counsel and to adjudicate it that way. And the fact that
Would that fix the system?
Yes. If it were, well, piece by piece.
If in the individual case, the defendant did not get meaningful representation, would that fix the entire system, or would it fix the injustice in that case?
Well, it depends on why he didn't get effective assistance. If, for instance, there were a policy of not making motions to suppress in a county that you establish.
Which is more likely to uncover that policy, the individual case or the kind of lawsuit that they're bringing now?
I think either one could uncover a fact.
Well,
There's nothing more or less likely for either point of view to uncover that fact. If it is a fact, I think the fact that they haven't alleged that kind of policy suggests
Are you really saying that if there is a true systemic breakdown where a huge number of people are not getting the right to counsel, what's going to happen is an awful lot of people are going to be let go because they're going to win their cases?
Well, I haven't said that.
Well, I invite you to say it now.
If it's true that a great many people have in fact suffered ineffective assistance of counsel in the sense that their lawyers failed to measure up to reasonable professional standards and it had some form of prejudice, whether it's the federal version or the state version, but had some impact on the trial, then yes, they should win their cases.
And so the result of a true systemic breakdown is going to be a lot of alleged offenders on the streets.
It might be.
Is there no other way to get a systemic fix other than case by case?
Not to the performance question, because performance, there is to policies, there is to absence at a critical
Let me
stage,
fence with you
but
about
to
that.
the judgment about whether the lawyer investigated enough, whether he made the right motion, whether he should have made a bail reduction motion or not, that is virtually impossible to adjudicate.
Senator, I worry a little bit about policies. I know, for example, that there are some counties up in my neck of the woods where the judge has a discovery order that comes out at the time of arraignment. He doesn't wait for the 45-day motion. if we then have a policy which says everyone must file a motion within 45 days pursuant to the we're going to change that, I assume. I think the judges then say, well, I can't issue my order promptly so that we can get this trial on, because now, according to what the state says, I have to wait for you to file this motion, and then I'll issue my standard order. I use that as an example because Lewis County is so much smaller than Erie County, which is much smaller than Nassau. I don't know how you join all of these. And that's why I was interested in counsel saying that she's only going after 5 counties, even though she's asking for class status. I'm trying to sort that out.
Well, I think that's one of the reasons why this can't be adjudicated on a systemic and prospective basis, because whether a particular practice denies the right to counsel, for instance, no counsel at arraignment, depends on what happens at arraignment. The appellate
What if the same thing always happens? That basically they just say, I'm not even trying to represent them, or they're not there every time, or whatever it is. Let's stay to the performance thing. Let's say the performance is outrageous, that it's clear, it happens all the time, they can allege it. In that kind of situation, you also can't bring this kind of action because it's a performance issue, or it would be capable of being proven if it's so clear and outrageous. Could it be so clear?
I think, for instance, if the allegation were that in a particular county the public defenders were always drunk in court, or
yes, let's say that they're always drunk in court,
something that virtually rose to the level of a policy or practice that might
okay,
but I don't believe that's what you're alleging.
But their contention is that their allegations are of that sort, that as a way. Why shouldn't, this is my question, what's troubling me is this is a 30-11 motion. Why shouldn't they be given the opportunity to show that as a matter of practice it's the equivalent of the person, they're always drunk in court every day. This is obviously more nuanced than that, but why shouldn't they be allowed to try and show that on a 30-11? Why shouldn't this proceed and see if they can prove their allegations?
Because I don't think that is what they're alleging. They're not alleging malfeasance. They're not alleging negligence. They're asking for things like supervision and training. They're asking for things like, that's a lot of what they're asking for.
On that issue, are we faced with an all or nothing proposition here? Or could we limit the scope if we decide to let this proceeding continue? In other words, we don't dismiss the petition.
I should think you would have the legal power to hold that the complaint was properly dismissed as to certain allegations and not as to others.
So there could be certain right to counsel issues that, for instance, we might find that are justiciable and should move forward, but other allegations that perhaps do not rise to the level of a constitutional violation.
I think in principle that's correct. I don't think there are such allegations here, but yes, I think you would have the power to partition the complaint that way and hold that it could only stand in part.
Suppose there were in some county a general practice of sending lawyers a year or two out of law school to defend murder cases. Does that could you bring a lawsuit to declare that practice unconstitutional?
Well, I think that claim would be justiciable. I think it would fail because you would be challenging a practice. You would be alleging as a systemic matter was on its face a violation of constitutional right. But I think that what's being alleged here is that by reason of I'm not sure what, because, I mean, that gets us to the remedy question, which isn't quite before us, but by reason of some general overarching state of conditions, or maybe different things in different counties, the lawyers just aren't quite measuring up. And
if legal aid in a county said, look, we're running out of money, we're going to waive all preliminary hearings from now on. We don't have time for them. We're not going to spend the time in court. So anytime there's an arraignment on a felony in an inferior court, the rule is to waive the preliminary hearing, let them be held by the grand jury, and we'll pick it up later. That, to you, would be a possible constitutionally justiciable issue.
I believe that's, you could, I mean, I'm reserving the question whether I agree that that would be a violation, but yes, that would be an allegation.
You were saying a policy of some constitutional import.
Yes. Yes, I think that that's correct.
So
and I think that's just not what's present here.
So your main problem is the complaint. You agree you could have a justiciable matter that we could hear if the complaint so stated it.
Well, I don't.
Is that?
That is a possible way of describing what I'm saying, but I don't think it's a simple matter of amending a few sentences here and there, because I think the complaint that I would say is justiciable is not actually the complaint that they wish to bring. They are seeking general upgrade in the performance of defense counsel, an extremely worthy and desirable goal, and one which the legislature may well soon address. There's, as you know, a bill in the governor's budget.
So you think performance can never be a constitutional violation? Is that what you're saying?
I attempted to answer that question.
Right,
I think
but that's sort of what you're saying.
In general, except at the extreme case, and that's because performance is so context-specific. I mean, these defendants allege that their lawyers don't contact them enough. But assuming the case is, I don't know what the case is, but assuming the case is simple and the evidence is strong and the lawyer contacted them initially and it's perfectly clear what needs to be done, the fact that they didn't contact them enough is neither here nor there. And I'm not asking you to adjudicate.
Say that that's a pattern, that they just don't contact them on a regular basis. That can't be a violation?
No, because sometimes it would be a constitutional violation and most often probably not. I think it's significant that these are all low-level crimes. Many of them, it's perfectly, I won't say what's clear because the facts are the fact, but it wouldn't be surprising if the best thing a lawyer could do for most of these defendants would be to get him a favorable plea quickly, which doesn't take a lot of conversation. Now, there may be cases that are different, but I don't think you can infer from the fact that 20 plaintiffs say that their lawyers didn't contact them enough, that 20 plaintiffs got ineffective assistance of counsel, much less that thousands of defendants not here before you got ineffective assistance of counsel. And by the way, this isn't a class action as it stands right now. It hasn't been certified as a class action. And even if it were, you'd have to have a plaintiff, a named plaintiff in the case who'd suffered the harm that they're claiming. And the only way they get there, since none of these plaintiffs, for example, pled guilty without counsel or even is contesting their conviction, is to claim that they all suffered from this amorphous systemic right of living through a system that had the potential to provide ineffective assistance of counsel. And no court has recognized that right.
Is the CFE a systemic failure case in your view?
No. The CFE, well, it's the closest maybe. But in CFE, this court held, and it was supported by the relevant legislative history, that the state had a constitutional duty to support a system of free common schools, a duty that was added to the Constitution in order to replace the previous unsystematic local method of providing.
Does the state have a comparable duty to supply counsel to criminal defendants?
The state has a duty to provide effective assistance of counsel. It does not have a duty to maintain a system that can be divorced from actually providing that counsel.
Say that again. What? They don't have to maintain a system in the state to
No,
provide counsel?
as long as the defendants get effective assistance of counsel, there is no particular requirement comparable to the CFE.
If a volunteer program in one county or all counties could do it, then the state would have no obligation.
That's correct. The question is whether defendants are getting effective assistance of counsel.
So the state only steps in, only would be required to step in if whatever was happening on its own wasn't sufficient.
I think that's all the Constitution requires. It would obviously be prudent to do something in anticipation, but the Constitution doesn't.
Would you say that every state in the Union has a system based on, since Gideon, has in the real world created a system to provide counsel, or is that not the case?
Well, it depends on what you mean by system. The obligation to provide counsel exists throughout the country. What the various states are doing about it, and whether you describe, if you wish to, it's almost tautological. You could say whatever is happening is the system. But I don't think that's the meaning of system that this court used or that the state constitution used in CFE, in which the state was actually mandated to create a system.
Where do the roles of the counties, the 5 counties involved here, fall in this equation?
Well, the way New York operates
I mean, when
its criminal
you're saying
justice-
state, are you including counties in that definition, or are we making a distinction between what assumptions and responsibilities the counties have assumed, separate from the state obligation here?
Well, the counties have been made parties defendant here. They haven't taken a particularly active role in this litigation. The way New York operates its criminal justice system, prosecution and defense, is on a county level, although the state provides some funding both to prosecution and to defense. And, of course, the county prosecutors prosecute in the name of the state, and the defendants are incarcerated by the state. So we aren't suggesting that the state doesn't have some ultimate responsibility here. But, for instance, the amount of money that is required to provide for defense turns entirely on how much prosecution is engaged in. And the state has no control over that. That is, the whole system, the prosecution and the defense, functions, and for that matter, court expenses, all the expenses are driven by intake, which is a locally made decision.
Isn't that what this case is about, whether the system is in balance? That the system they're alleging through their specific allegations that the system is totally out of whack, and that that's why there isn't a meaningful counsel provided, that on that side of it, not the prosecution side, and we have amicus here from prosecutors, or former prosecutors.
They're both.
Yeah.
Current prosecutors who object to the claim, and former prosecutors who are now defense counsel who endorse the claim.
But I guess what I'm leading to is the same question I asked your adversary. Do we have a particular role to play here, given that this is about the justice system, the court system, that it works? Can we take just a hands-off approach and say, listen, there's no real controversy here, just have the individual cases go through to completion? Or does it matter that this is about the justice system, about the court? Should it matter to us?
I think it matters in the sense that it makes it very important. But making it very important doesn't make it justiciable. It doesn't – it's not justiciable because it's so hard to determine prospectively if even one person is being denied the right to effective counsel, much less –
What made NYCLA justiciable?
Well, I think there are two things to say about NYCLA. One, it's not entirely clear that NYCLA was correct, but two, it was, as Judge Smith pointed out, not a claim that asked the court to measure the performance of attorneys, but just a claim for money. My adversary says this case is easier. I think it's much harder than a claim for money, not that a claim for money is easy either. But this requires a court to determine that the behavior of hundreds of attorneys in thousands of cases falls short, one, falls short of professional norms, and two, falls short of those professional norms in such a way as to call into question the fairness of the proceedings. Those are judgments that cannot be made on a prospective class-wide and systemic
I realize your red light is on. I have one last question. How, other than a lawsuit of this nature, can you bring the two political branches' attention to this type of situation?
Well, I believe that there is very promising legislation pending right now that might well actually accomplish this purpose. This is not the only branch that is authorized to act in matters of great importance, and I think this Court has regularly attempted to both limit the judicial role to its proper role and at the same time say something about what it thinks the other branches should do.
Okay. Thank you, Counsel. Counselor Rebuttal?
Thank you, Your Honor.
Well, NYCLA didn't go any further, obviously, because there was a statutory fix. The compensation was adjusted upward, so there was no need to proceed. Why is there a need to proceed here, absent pending legislation?
If the state were to cure the problems addressed in the complaint and moot out this complaint, no one would be more thrilled than the plaintiffs.
And you would withdraw your complaint?
Of course.
Did
That hasn't happened, so we're here.
Did NYCLA have anything to do with performance?
Yes, Your Honor. This case is not different from NYCLA. The relief there might have been ultimately raising the fees, the wages. But the proof there was the same as the proof here.
But in terms of justiciability, isn't it relevant to the justiciability question whether you can have some reasonable prediction at the beginning of the case what the end of it might look like?
Absolutely, and I think we can have.
But you keep saying, I keep asking you, is this going to be a lot of money? What kind of remedies are you going to order? And you keep saying that's for tomorrow. Isn't that answer in itself a reason not to entertain this kind of case?
No, I hope that I answered that question a little bit more than that, although certainly that's the starting point. But let me answer that question by addressing what you just brought up in terms of comparing this case to CFE. The reason why this case is easier than CFE is that to determine what the dollar amount was in CFE, this court and the lower courts had to undertake an incredibly complex analysis of what the right to a sound and basic education means. Here, we know what the right to counsel is. It's the right to meaningful and effective assistance of counsel at all critical stages. That term is well defined.
And in the real world, that's going to cost money, isn't it, to do an adequate job, more money than they're spending now?
Your Honor, that may be true. It may not be true.
And it's certainly true that you have no idea how much more.
That's absolutely true. I have no idea. But the right to counsel.
Isn't that a problem with systemic failure cases? That what you're really doing is you're signing a blank check by upholding the complaint, you signed a blank check that someone's going to fill in later?
Your Honor, Gideon v. Wainwright stands for the principle that the state has to provide lawyers to poor people who can't afford them. That inherently requires the state to spend money. That is not a reason for this court to run away from enforcing the constitutional right to counsel.
Counsel, what about your adversary's argument that you can't measure performance? She says that there's no way that it requires the individual case looking at what happened with the attorney who represented the defendant. Is that what's your answer to that? Can you in this kind of an action show enough in relation to performance that we would show a constitutional infirmity?
Absolutely, and the complaint does show that. The complaint
Tell us.
The complaint alleges, for example, that in 2 out of the 5 counties, $0 were spent on investigative services in the previous year before the complaint was filed. The complaint alleges that lawyers with no experience in criminal defense work are representing people in complex cases. These kinds of systemic failures are, in fact, causing real violations.
So is this a variation on a theme from the hypothetical was given before that I think by your adversary, that every lawyer shows up drunk, we know there's a problem? Are these also things that we know there's a problem if we allow this to continue?
Yes,
get past a motion to dismiss?
That's right. And let me bring another hypothetical, which is Judge Piggott's hypothetical about the case in which there was a policy of waiving preliminary hearings. That's what we have here, except instead of a policy, it's a practice. And that's what the complaint alleges, and we're not the only ones who think this. The Kay Commission report says
It's a lot harder, but proving a practice is a lot more complex process than proving a policy, isn't it?
Well, we have no illusions this is going to be a difficult case. But
and among the problems is that there's a question of how many it takes to make a practice. If you've got 100, maybe it's a practice, or maybe it's 100,000 cases, maybe it isn't. How do you know? How are you supposed to figure out something like that?
Well, the complaint alleges that these are happening on a widespread scale.
Okay, but ultimately, if we uphold the complaint, that means we're going to give you a chance to prove your allegation. How do you prove that something's a practice?
Well, Your Honor, you prove it by showing that it's happening in an inordinate amount of cases.
Oh, but is there any way to answer that question without using an adjective like inordinate?
This Court, what your question gets at is how bad does it have to be to violate the Constitution fundamentally?
Yes.
And the answer to that question is whatever that level is, the complaint clearly alleges it. We are talking about
But doesn't somebody ever I guess what I'm really saying is, doesn't your complaint inevitably require an answer to that question? And doesn't that raise justiciability problems? Because it's a very, very hard question for a court to answer.
Well, simply because it's a difficult question does not make it non-justiciable. Because
the
question is what's the nature of the question.
That a court is particularly bad at answering, that could make it non-justiciable, couldn't it?
But this Court is very good at answering that question.
One of the issues, and I was struck by the investigator point that you made, that it's not very – sometimes judges won't let you have them. You have to apply to the court to get an investigator if you're an assigned counsel. They turn you down. There's many cases where you don't need them. There's many cases where the defendant says, look, give me the best deal you can and I'll get out of here because I'm already serving so much time on something previously that this makes no difference to me and I don't want to stay here. There's a lot of reasons why cases get decided the way they do, absent this systemic problem. And I'm wondering how you're going to sort that out, because if as you indicated, you're going after 5 counties, that's interesting. Maybe you can show that Onondaga County is doing something or that Schuyler County is doing something or so forth. But as I read your complaint, you were asking for class certification.
Only as to the 5 counties, though, Judge Pickett. I want to be clear. The class is indigent criminal defendants in the 5 counties.
Is it fair to call those 5 counties a test case for the rest of the state?
As far as we're concerned, we are only here to bring a complaint on behalf of the class of indigent defendants in the 5 counties and obtain relief from them. That is all we're asking the court to do.
But you wouldn't be here if you thought the only problem in the state of these 5 counties. Would you have brought this action?
Yes. I mean, all indigent criminal defendants have the right to counsel, even if it was one county.
But you didn't pick them because that was the case.
No, Your Honor, no.
I mean, you want to pressure the legislature and the governor to provide more money into the system, I take it, on a statewide basis, correct? Now, you don't just want additional funding for these 5 counties, do you?
That is all we're here to ask the court to do, and that's all we can ask the court to do. We are here only representing the indigent criminal defendants in those 5 counties. We are only seeking...
Yeah, but in reality, I think what we've all been talking about today, the import of this clearly from your perspective, and your adversary recognizes it too, relates to the indigent defense system in this state, not just in those 5 counties.
That's right, and the complaint incorporated the K Commission report into its allegations, which is a report that is directed at the state in general. But when it comes to the questions that this court has addressed about its own authority to enforce constitutional rights and how far it can go in doing that, I think it's important for plaintiffs to emphasize and for the court to recognize that the complaint itself is on behalf of indigent defendants in 5 counties.
Okay, guys. Thank you both. Appreciate it.